Welcome, everyone. My name is Andrew, the founder and owner of IBIS Prep. Tonight, we're continuing the July 2025 complete course for the Florida Bar Exam, and I'm going to go over every single essay subject. Going to start with contracts. Buy friends drinks, big drinks is the mnemonic that we can't forget. What does that stand for? Body of law, formation, defenses, breach, and damages. Let's start with formation. Formation, you need to consider whether it's going to be governed under the UCC or common law. Common law is going to be for services or land, whereas the UCC governs goods, which are all things movable. Once you've thought about this, you should also consider what type of contract are we dealing with. And there's multiple different types of contracts. There's unilateral contracts, which can be accepted by performance. There's bilateral contracts, which are going to necessitate contract formation, offer and acceptance. There's options contracts, which can be held open for a specific time. And we got to remember the firm offer rule. If a merchant makes an option contract and it's in writing, then there does not need to be consideration to hold it open. Otherwise, options contracts, offers that will remain open, will require consideration. There's requirements contracts and outputs contracts, requirements and output contracts. Requirements are when someone agrees to supply all that is needed, right? All that is required is a requirements contract. Whereas an output contract is where a party agrees to purchase all that is produced, whatever they output. So those are different types of contracts. We have installment contracts and divisible contracts. Installment contracts are contracts that are reoccurring, let's say reoccurring delivery or shipments or weekly performance. And it's interesting to note that in installment contracts, a breach may not constitute a material breach because there's an opportunity to cure. So as I'll talk about under the UCC perfect tender rule, usually you have to ship conforming goods. But if it's an installment contract and there's one non-conforming shipment, they may have the opportunity to cure on a subsequent installment, so long as it does not materially alter the rights and obligations of the contract. There's a divisible contract. A divisible contract is a contract where it can be argued can be divided. Let's say it's to paint multiple houses. Well, we have an agreement. It'll be $1,000 per each house painted. So let's say one party paints 3 of the 5 houses and then breaches and says they're no longer going to pay. They could argue that's a divisible contract and they will be entitled to get paid for painting the first 3 houses, minus any damages that are incurred by the non-breaching party for having to go out and find a new party to paint the remaining houses. You can distinguish a divisible contract from a construction contract in the sense that a construction contract would have like a person putting in the floors and then a person building the painting the walls and then putting in the fish tank or whatever it may be. And in that construction contract, it's really not divisible because it's just a continuous project. Whereas a divisible contract truly is divisible in the sense that it can be divided without significant impact on the remainder of the contract. And then there's a quasi-contract. A quasi-contract is a court-enforced contract, a contract in equity. You can think of a quasi-contract in reformation. I'm sorry, a quasi-contract in restitution, which would be an action to disgorge ill-gotten gains. You know, you all paid a deposit to join my class. I didn't show up. I was at the beach, and then you want to get your deposit back. Well, you would be entitled to that deposit returned in an act of restitution. But what would be the underlying contract that, places obligations on my behalf? It would be a quasi-contract, a court-ordered fictitious contract that imposes my obligation to pay you back the deposit and your right to receive that money in restitution. So you can think of all the different types of contracts. When we're also thinking of contract formation, it's important to consider if the parties are merchants. And they're going to give you some language in the essay which might point you to the idea that they're merchants, people who commonly deal with the goods being contemplated in the contract. And if they're merchants, there are special rules that apply under the UCC. Like I said, the firm offer rule is a good example. And then the concept where there's no need for consideration if there's a modification, or the battle of the forms provision is a great example. So we'll talk about that when I talk about formation, but I just think at the beginning, you should kind of have these points in mind. First and foremost, is there a contract? A contract is an agreement between two or more parties in which there are valid remedies at law. Next, we must decide if the contract will be governed by the UCC or common law, UCC for goods, which are all things movable, and common law for land or services. Then we want to determine what type of contract are we dealing with, and consider if the parties are merchants, because there are special rules that will apply to merchants. Maybe consider the predominant purpose test, which would say if the contract is considering services and goods, you'll look to see which predominates the contract and apply the corresponding law. Unless you could argue the contract is divisible and then apply UCC to the one part and common law to the other part of the contract. Again, these are all arguments you can have. You'll see model essays are very quick to be like, the first issue is whether there's a contract under UCC or common law. Common law is for services, UCC is for goods. This is a good, therefore the contract is governed by the UCC. I'm a little bit more robust and articulate. I'm also a very fast writer, thinker, mover, runner. I beat my friend Tariq in the 5K. I'm just fast in general, and then I can work under time conditions. It's not common. So, most people really are up against the clock. So you got to balance, can you talk about all these things I mentioned, or do you want to just write a quick statement and get to the next issue? At the end of the day, you need to practice and in practice, kind of find your rhythm and your balance and see what type of person are you. I have a feeling Andy, who was, teaching before I came on, could write similar or honestly better essays than me, because she's the same. She's just very quick witted and quick with her understanding and recognition of issues, and she knows the rules and she knows how to write them. If you're someone who kind of takes a little bit to get the wheels turning or whatever, you might want to stick to the more just the facts approach. But at the end of the day, Florida essays are rubric based. You want to write as much as possible and give the reader as many opportunities to give you points as possible. Imagine, I know it's hard to imagine, that it's a robot grading it, like a artificially intelligently designed robot, and it's just going to be programmed to be looking for issues, rules, analysis, whether you took this side or that side, and then again conclusions. But less importantly, it's more issues, rules, and stances you took either way. But the readers, who I imagine will become automated over the next few years, just like all of society, unfortunately. I think that's kind of how they're already programmed to grade. It's very robotic. It's very much like, these are the rubric points. Did you mention it? Did you write the rule? Did you have the discussion? Can we get as many points as possible? Try to write these essays in a manner that you can't fail, meaning you're just going to give the reader all the rules that are relevant, and really just write perfect essays. I know that sounds crazy, it's a lot, but just try to overdo it if possible. But at the same time, don't run out of time. I've had students who've written 2 great essays and 1 horrible essay. They ran out of time, they're going to fail. I would rather you write 3 good essays than 2 great essays and 1 mediocre, right? So balance your time and try to be strict on your time parameters. So the body of law, the formation, offer, acceptance, and consideration, right? Offer meaning a manifestation of intent to be bound by the contract in a way that gives power of acceptance in the offeree. And then acceptance is assent to that contract, right? There must be mutual assent and a meeting of the minds, and on behalf of both parties, an intent to be bound by the terms of the contract. Sometimes there's essential terms, like under the UCC, we're going to consider if they have the quantity and identification, not if it's a let's say requirements contract. You don't need the quantity because it's indefinite, but the usual UCC requirement is that you do have the quantity, not the price. The price can be ascertained. If it's a land sale contract, certainly we need a description, identification of the property. If it's an employment contract, the salary is a very important term. When we're talking about offer acceptance, consideration, a bargain for exchange of legal detriment or value in Florida. And then remember, UCC is the battle of the forms provision between merchants, where an additional term, if immaterial, will be included in the contract. If it is material, it will be knocked out, but the contract will still be formed. If it's UCC and they're not merchants, the contract will still be formed, but the additional term, whether immaterial, material, will be considered a proposal to be potentially added into the contract. At common law, we follow the mirror image test. The mirror image test means that the terms of the acceptance must match the terms of the offer exactly. So you want to realize that at common law, they're much more strict in terms of contract formation, that acceptance and the offer must match. Whereas under the UCC between merchants, additional terms, ballot the forms, there's a little bit more leeway. It's the opposite when it comes to contract execution. For execution, under the UCC, we have the perfect tender rule where it has to be an absolute conformity. Under the common law, there's a little bit more leeway as we have the substantial performance test. So it's kind of a way of thinking about it. UCC is more lenient when it comes to formation, but more strict when it comes to execution. Common law is more strict when it comes to formation, but more lenient when it comes to execution. These buzzwords, mirror image test, battle the forms provision, knockout rule, those are buzzwords you should try to incorporate in your essay. When we get to the next step, which would be defenses, I've never seen a contracts essay that doesn't talk about the statute of frauds. Statute of frauds, the mnemonic is my legs, contracts in contemplation of marriage, contracts that cannot be complete with 1 year, contracts for land, executorships, goods over $500, and suretyships. Florida also has healthcare guarantees and some, additional contracts that if you see in the essay, think about should that be in writing, and maybe it might be the case. If you talk about my legs, you should also talk about swap. Swap are exceptions to the statute of frauds rule. And again, the statute of frauds means that there are certain contracts that must be in writing and signed by the party to be charged. The exceptions are specially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. These are ways that we can overcome the need for a contract to be in writing. So if you see a merchant who sends an email confirming the terms of an oral agreement, that likely signifies a confirmatory memo exception. Other defenses to contract formation or execution would include fraud, duress, misrepresentation. A lot of defenses start with I, illegality, illusory, incapacity, intoxication, infancy, and then execution, impossibility and impracticality. Also execution, frustration of purpose. There's other defenses that start with U, unconscionability, undue influence, procedural or substantive unconscionability. Undue influence is different than duress because duress is a threat, where undue influence suggests a abuse of a special relationship between the parties. There's latches, acquiescence, unclean hands, a lot of, let's say remote defenses to contract formation execution that you can think of, but the big ones would be those. And then of course, mistake, mutual or unilateral mistake. A mutual mistake would give rise to reformation or rescission of the contract because there's no meeting of the minds, where a unilateral mistake, it depends. If the mistaken party knew of the non-mistaken part, if the mistaken party knew of the non-mistaken party's mistake and essentially took advantage of them, then that would give rise to rescission or reformation because they essentially took advantage of the mistaken party. Whereas if the non-mistaken party had no reason to know of the mistaken party's mistake in a unilateral mistake situation, then the unilaterally mistaken party would likely be bound by the terms of their mistake. So understanding, all the defenses, statute of frauds, mistake, fraud, duress, misrepresentation, a lot of them that start with I, intoxication, illegality, illusory, incapacity, infancy, and then execution, impossibility, impracticality, frustration of purpose. A few of them start with U, undue influence, and unconscionability, procedural and substantive. And then thinking of the more fringe defenses like latches, acquiescence, and unclean hands. Then we get into the breach, and breach could be either material or immaterial. And the breach could also be anticipatory, and anticipatory repudiation, which is an unequivocal demonstration of intent not to honor the obligations of the contract. Material breach will get to the heart of the contract, or immaterial will not, and will only give rise to minor damages. And then the damages section, where people really struggle with, think of these buckets, right? There's 4 buckets, 2 on each side. legal, and equitable. The first bucket, the big bucket, is expectation, consequential, and incidental. Expectation damages will put the non-breaching party in a position they would be if the contract had been performed. Consequential damages are damages that are foreseeable in light of a breach. They're considered recovery for lost opportunities. And then incidental damages are damages that are incurred as a result of mitigating the losses. And remember the duty of mitigation, think about the cost of cover, think about some of these factors that might be relevant when doing a damages analysis. So the first bucket, and I use that term because it's kind of like term. Hey, what's up, John? First bucket I would say is expectation, consequential, and incidental. And then the second bucket would be reliance damages, restitution, and liquidated damages. Reliance damages when one party detrimentally relied under theory of promissory estoppel. Restitution is to disgorge ill-gotten gains. So think of restitution in one instance as, someone paid a deposit and they didn't perform, so they're going to get their deposit back in restitution. They incur gains. Or also think about it as potentially the breaching party's way of recovery. Like, Tommy built half a structure and then breached the contract and moved out of town, but he should still get paid for the half a structure that he built, right? Well, that would be considered an act of restitution because the other party was unjustly enriched by having half a structure built. These are some times where restitution would potentially be proper. Or let's say Tommy's building a property and then it burns down with the fire and they decide not to go forward. Well, Tommy probably would still get paid for his services in an act of restitution, specifically quantum meruit. But these are just some considerations. So the other type of damage in this bucket would be liquidated damages. Liquidated damages are contemplated in advance and they're proper when damages would be too speculative in the event of a breach. They must be reasonable and cannot operate as a penalty. So look for, a contract where it says in the event of a breach, this is the amount that Tommy's going to have to pay. Well, that would be considered a liquidated damages provision, and it's got to be reasonable. If it's 50% of the contract price, in fact, if it's over 20% of the contract price, it might be presumed unreasonable, but it could still be over 20, right? You just kind of have to look at the facts and see. But if it's 50% of the contract price, in the event of a breach, you have to pay 50% of, the contract price. That would be considered an unreasonable liquidated damages provision. So those are some forms of legal relief. Remember, the first bucket is expectation, consequential, incidental, and then the second bucket is reliance, restitution, and liquidated. Reliance and restitution, and even liquidated, could be equitable in some sense, but that's why it's a smaller bucket because it's a little confusing. Then in equitable relief, the first big bucket is specific performance for art or land, right? Reformation and rescission. Reformation to modify the contract to, illustrate or to exemplify the meaning, the intent of the parties, modify the contract so that we can actually perform the contract as the parties intended it to be. And then rescission, which is putting the parties in the position they would be if the contract was never entered into, right? Expectation is if the contract was performed, whereas rescission is canceling the contract, eliminating the obligations of either party and putting them in the positions if the contract had never been entered into. So I like that first bucket of specific performance, reformation, and rescission. And then the other bucket I think about with equitable relief would be promissory estoppel, quasi-contract, and injunctive relief, right? Like a replevin or something. So quasi-contract is a fictitious contract, like I talked about, like a quasi-contract in restitution. So it's kind of equitable legal right across. And then again, promissory estoppel is that detrimental reliance theory. And we also talked about promissory estoppel when I mentioned it's a exception to the statute of frauds with the swap mnemonic, right? Especially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, partial performance. So some of these concepts overlap, right? Is it a remedy or an exception to the statute of frauds? It's kind of both. Is it legal or equitable? It could be either, depending on the situation. So those are some thoughts. And then injunctive relief, like a temporary restraining order or a non-compete. Non-compete agreements have to be reasonable in geographic scope, in subject matter, and in duration. So those are some key points about contracts. Also maybe think about accord and satisfaction, an agreement to extinguish an earlier debt with a payment of a lower amount or something. Think about modification, modifying a contract, UCC versus common law. Law will require consideration unless it's fair and equitable under the circumstances and is to modify something that was unanticipated at the time the contract was entered into, but usually common law modification will require consideration. And then parole evidence, we're not going to allow oral evidence or outside evidence to contradict the terms of a fully integrated contract unless it's to show condition to contract, ambiguous terms, to show defect information, or to show trade usage or customs, or maybe that show an additional term, but it won't be coming in to contradict an actual contract. And then Andy made a good point about third-party beneficiaries. She feels like it might be tested. Third-party beneficiaries, that's the concept where certain third parties may have rights in a contract if they're contemplated to benefit from the contract. And if they start, relying on the benefits, then their rights could vest and they could stand in the shoes of either party in the contract and enforce those rights and even bring suit. So intended beneficiaries could potentially have these rights, whereas incidental beneficiaries will not have these rights. And if you can't tell the difference between an intended or an incidental beneficiary, think, was the person who's trying to bring a claim contemplated by the parties to potentially stand in the shoes and assert rights if they weren't there to assert rights. So it's kind of tough to distinguish, but if you're mentioning these points, you should get a lot of points on the exam. So again, I got a lot of subjects to go, but I want to start with contracts and do a nice little rendition. When it comes to torts, there's some important pieces. First and foremost, Florida is a modified comparative fault state, which means that anyone over 50% at fault will be barred from recovery. In these negligence claims, we have abolished joint and several liability. So you would have to recover from each defendant jointly, or each defendant severally and not joint and severally. Florida has a limitation on punitive damages, which is 3 times compensatory or $500,000, the greater of the two. So those are 3 points you can pretty much just get out of your system on torts essays and get points for. The modified comparative fault, the abolishment of joint and several liability, and the fact that punitive damages are limited 3 times compensatory or $500,000, except in certain instances where it's really gross wanton negligence, like towards the elderly or special needs, let's say. There are intentional torts: assault, battery, false imprisonment, trespass to land, trespass to shadows, conversion, intentional infliction of emotional stress, intentional interference of a business relationship, tortious interference, intentional misrepresentation, malicious prosecution, intentional endangerment. Elements of the privacy torts. The privacy torts are false light, which is not recognized in Florida, intrusion upon seclusion, appropriation or misappropriation, and then public disclosure of private facts. And then you could also think about there being intent when it comes to defamation if it's of a public figure. So defamation can be of a private figure, which would require negligence, or of a public figure, which would require a showing of actual malice. Florida for defamation has the media defendant rule, where the person, the celebrity, let's say, who's alleging defamation has 5 days to make a claim, to provide notice, and then the newspaper will have 10 days to retract that statement, and then they can't be held liable for any damages outside what was actually the harm they actually caused, not any further reputational damages. Like was said before the recording, slander is spoken, whereas libel is written or published. Slander per se is for crimes of moral turpitude, loathsome disease, a woman's chastity, or relating to a person's business. And then truth, or what Andy said. What did Andy say? I thought I wrote it.
Privilege?
Privilege, yeah, there we go. I was looking for it. Truth and privilege can be defenses to defamation. Just so I don't forget what Andy said, because Andy was killing it, she mentioned a bunch of defenses. Defenses to intentional torts include consent, self-defense, necessity. Defenses to defamation include truth and privilege. Defenses to negligence include comparative fault. We said Florida's modified comparative fault, not meeting an element, right? There was no duty. And then the class kind of added statute of limitations, res judicata claim preclusion, maybe vicarious liability. And then defenses to strict liability could be unforeseeable misuse or assumption of risk or alteration to the product. And then defenses to nuisance could be unusual sensitivity or removed into the nuisance. Yeah, nuisances are potential claims that can be brought if there's an annoyance to a neighbor or something similar. So when I talk about torts, I invite the writer to throw the kitchen sink and try to identify all the torts. I give this example. I step outside, my neighbor throws a rock at my head and says, IBIS prep sucks. What claims can I bring? Assault and battery. You caused reasonable apprehension of an offensive touching, and then there was an offensive touching. 2, trespass to land. You caused the rock to intrude upon my property. 3, IIED, NIED. Now, every time I walk outside, I fear that there's going to be a rock thrown at me. I can't sleep. I'm having restless nights. I'm having, tremors, all these different factors. And then potentially defamation. You yelled, and I live in a townhouse, IBIS prep sucks. Well, we don't, first off. And second off, what if my neighbor heard and now that's a third party and you said something, injurious to the reputation of my business? Well, that's a lot of potential claims, right? So there's negligence, there's intentional torts, there's all sorts of plausible claims that we could bring in that instance. And that's how I want everyone to think. Maybe you can say, oh, well, assumption of risk. I didn't really assume the risk, but it's a possible argument that would likely fail. Maybe you could say that it's comparative fault. Maybe I shouldn't have swung the door open and embraced the sky like that, right? There's arguments that will likely fail. That's a talent, writing about arguments that will likely fail. Of course, negligence, duty, breach, causation, and damages. Remember that for causation, there's actual and proximate. Actual is but for, whereas proximate is the foreseeable plaintiff. There's NIED, which is different from IIED because of the intent element. There could potentially be a bystander claim or a zone of danger claim. So think about these concepts when you're writing about NIED. In general, like I said, torts is just throwing the kitchen sink at the reader. There's strict liability, which is for wild animals, inherently dangerous activities, or products liability. For products liability, it's when a manufacturer, producer, supplier, retailer, or distributor, someone, a commercial entity, places a defective product in the stream of commerce, and then anyone downstream can be held strictly liable for injuries. There are different theories of strict liability. There's a manufacturing defect, that it was made improperly compared to how it was designed, like it came off the line differently. And then there's a design defect, which is a failure of the risk utility balancing test or the consumer expectation test, where the risk of designing it one way outweighed the utility of designing it another. There's the express warranties, like failure to warn or inadequate warning. And then there's the implied warranties of merchantability and fitness for a particular purpose. Remember this, whenever there's an argument for strict liability and prox liability, there's a contemporaneous argument for negligence. It was a breach of the duty to design it this way or to manufacture it this way. Florida recognizes the dangerous instrumentality doctrine, where, if you lend someone your car or your boat, you could be held vicariously liable. Be on the lookout for vicarious liability, respondeat superior, an employer-employee situation where one party can be held vicariously liable for the negligence of another party. These are some major considerations when it comes to torts. And then premise liability. It's a duty, breach, causation, damages analysis, but you really want to focus on who is the duty owed to. Are they an invitee, a licensee? Florida has the license invitee, which is kind of saying that social guests have a heightened duty owed to them. But in general, the hierarchy is invitee, licensee, known trespasser, and unknown trespasser. You really owe minimal duties to the unknown trespasser, except not to cause harm to them intentionally. To the invitee, the business guest, you actually have an additional duty, not just to make safe dangerous conditions and to warn of dangerous conditions, but also to do reasonable sweeps and inspections of the property, right? If it's like a store and there's bananas on the floor, you got to argue that the store should have cleaned up the the aisle, and they breached a duty in that sense. Res ipsa loquitur, the thing speaks for itself. It wouldn't have happened in the absence of negligence, and it was under the exclusive control of the alleged tortfeasor. Negligence per se, statutory negligence, there's a duty that creates a standard of care, and it was breached, like a traffic ordinance or something of that nature. A lot of different things you could talk about when it comes to negligence, but some key pieces, remember, abolish joint several liability, a modified comparative fault state, a limitation of 3 times compensatory of $500,000, be on the lookout for vicarious liability, respondent superior, and then heavily tested torts are premise liability, products liability, and defamation. And then obviously the intentional torts and negligence, you should try to throw the kitchen sink at them. When it comes to con law, it's a tough subject because there's multiple lenses. There's the federal lens, the Florida lens, and the con crim lens. The Florida lens is specific to Florida issues like the Sunshine Law and the homestead exemption, enacting a law in Florida, general laws versus special laws versus general laws of local application, ad valorem taxes, municipal bonds in Florida, suspect classes in Florida, and different considerations like the Kluger Doctrine and the right to felons, which is limited, including the fact that they cannot vote unless they've had their voting rights restored. So a lot of different, starting with the Sunshine Law. Sunshine Law is a right of access, so all the people, the public, have a right of access to governmental proceedings and discussions and meetings and minutes. And the only exception is if it's an unplanned meeting between two legislators, and they're not really talking about, governmental matters. The argument against the Sunshine Law that the legislators will make is that they have a heightened right to privacy in Florida, but that argument will fail, but you should still make it on your essay because the Sunshine Law is a sacred right of the people in Florida to access public proceedings. The homestead exemption will cover half an acre inside a municipality and 160 acres outside a municipality in Florida from outside creditors, except for judgments on the property itself, like mortgages, liens, homeowner fee, attorney's fees for procuring the homestead, things that are related to the property itself, encumbrances on the property. And then also governmental judgments and taxes, property taxes, of course. Ad valorem taxes are collected by local municipalities and counties, not the state. So be on the lookout for that. Municipal bonds, there's general obligation bonds and revenue bonds. General obligation bonds are like public parks or schools, and they require a vote or referendum, whereas revenue bonds are backed by the actual revenue of the project, like a toll bridge. To enact a law or ordinance in Florida, there's some considerations, right? The bill in itself has to have a single subject. It has to have a clear title. It has to be related to the health, welfare, and morals of the people. It has to have an enactment clause, and it cannot be vague or overbroad. And then to become a law, it has to conform with bicameralism, meaning it's read into each legislator 3 times, and then it's presented to the governor for signature. Florida does not recognize a pocket veto, right? If the governor does not sign it, then it does become a law, which is not the same in federal law. There could be a special legislative session where the governor calls a legislative session for a particular meeting, and they can only talk about the particular reason why it was called for unless they get an override with 2/3 vote in each house. There's certain things that require a 60% vote, like amendments to the Florida Constitution. That's why you saw that with the abortion and the marijuana amendments. They did require that 60% vote. In Florida, there's general laws, special laws, and general laws of local application. General laws apply to the state uniformly. Special laws will apply just to the county. And then general laws of local application are based on population. Special laws will require a vote or referendum from the affected county. Florida municipalities have what's known as the home rule power, which is the power to enact laws and ordinances that do not conflict with the general laws of Florida. Florida recognizes the Kluger Doctrine, which is the concept that the right to access courts could be restricted if there's an overarching public necessity. Fundamental rights in Florida include race, alienage, and national origin, also disability. And then on top of that, the right to work, the right to travel, the right to form a union or be in a union, unionize, the right to own a gun, anything, I'm sorry, constitutional, the right to privacy, due process, right to trial by jury, confrontation clause, right? All these, constitutional rights are considered fundamental in Florida. And then, we can consider the federal rights. Always be on the lookout for due process and equal protection. Due process stems from the Fifth Amendment. So in the Fifth Amendment, you have the right to procedural and substantive due process. Consider the takings clause, that private property shall not be taken without full compensation in Florida. There's the concept of the right against self-incrimination, the right against double jeopardy, and your Miranda rights, which also stem from the Fifth. And then, your First Amendment rights, right? Your freedom of speech, freedom of religion, freedom of press, freedom of petition, freedom of assembly, and in consideration of content-based or content-neutral restrictions. Content-neutral being time, place, and manner, whereas content-based is subject to strict scrutiny. Make sure you understand the different scrutiny levels, which can arrive from the 14th Amendment, equal protection. Equal protection is when they're targeting a specific class. Substantive due process is when everyone's rights are being impacted. The standard for strict scrutiny is that the government must show that the state action is necessary to achieve a compelling government interest. It's narrowly tailored and it's the least restrictive means possible. Intermediate scrutiny, which applies to gender and illegitimacy, means that the government shows that the action is substantially related to an important government interest. And then rational basis, the plaintiff must show that the state action is not reasonably related to a legitimate government purpose. Now, for content neutral time, place, and manner restrictions, it's a heightened version of intermediate scrutiny where the state must show that it's narrowly tailored to an important government interest and leaves open alternative avenues of communication. And you consider public forums, traditional public forums, limited public forums, designated public forums, non-public forums. And, if it's a non-public forum, it only needs to be viewpoint neutral instead of content neutral. These are just some, deep dive issues on the First Amendment. First Amendment, Fifth Amendment, 10th and 11th Amendment, 10th Amendment, state sovereignty, 11th Amendment, sovereign immunity, and then 14th Amendment, equal protection, thinking about discrimination against a particular class or some state action that may be problematic. As Andy said when she was presenting, look for standing, justiciability, and state action. So it has to be right but not moot, and there has to be injury in fact, causation, and redressability. So a lot of key topics you can talk about in federal con law. And then for con crim, it's mostly Fourth, Fifth, and Sixth Amendment. And Fourth, Fifth, and Sixth Amendment is Fourth Amendment, you're right against unreasonable search and seizures, the exclusionary rule, and the free the poisonous tree doctrine. Make sure you understand the spaces mnemonic, search instant to arrest, the plain view doctrine, the automobile exception, consent, exigent circumstances, and stop and frisk. And then the exclusionary rule, we're going to suppress any evidence that's seized in violation of the Fourth Amendment. And then for the poisonous tree, any evidence that is derived from improperly seized evidence will also be excluded. For them to have a warrant, they need to have probable cause and get it issued by a neutral magistrate that accurately describes what the items being seized or the persons be arrested. Fifth Amendment, like we talked about, has Miranda rights, and then you're right against self-incrimination, you're right against double jeopardy. Your Miranda rights are your right to remain silent, that anything you say can and will be used against you, your right to an attorney, and that if you cannot afford one will be provided for you. And Miranda rights apply when you're in a custodial interrogation. Custody is when you will not feel free to leave, and then interrogation is anything that would result in an incriminating response. The difference between Fifth and Sixth Amendment right to counsel is that Fifth Amendment right to counsel is when you're in custody, whereas Sixth Amendment right to counsel is after charges have been filed. Fifth Amendment right to counsel is general, whereas Sixth Amendment right to counsel is offense specific. Eighth Amendment is against cruel and unusual punishment, right? These are some considerations of the criminal procedure discussion. And remember, when you're on the Fourth Amendment, where do you have a reasonable expectation of privacy? If it's the trash inside your house, certainly. If it's the trash that you put out to the curb, then certainly not. And just have these, well thought out discussions on the exam. Real property, I believe, is the toughest subject for people because of the different blueprints that the essay could go. I think most commonly tested one would be talking about mortgages and conveyances and things of that nature. So from the top, understand that Florida is a pure notice jurisdiction and that Florida is a lien theory state. Florida is a pure notice jurisdiction. That means that we're going to protect bona fide purchasers. A bona fide purchaser is someone who takes for value in good faith without notice. Notice can be one of three ways: actual, inquiry, or record notice. Inquiry and record notice are types of constructive notice. Actual notice means they actually knew of the encumbrance on the property or the interest in the property. Whereas inquiry notice means a reasonable inspection of the property would have put you on notice, maybe shown their possession. And then constructive notice, record notice, would be it's in the county records, and they should have just checked the county records to see about the interest, and they'll be ascribed with notice. So if they don't have notice, they took for value and in good faith, they'll be a bona fide purchaser, and that person will prevail in Florida because it's a pure notice jurisdiction. Florida is also a lien theory state. What that means is if there's a JTROS, a joint tenancy with right of survivorship, and one of the parties takes a loan out on the property, that loan will not sever the JTROS. Therefore, if A and B are joint tenants with rights of survivorship, A takes a loan out from C, and then A were to die, C could not foreclose on the property because C does not have title to the property. C merely has a lien on the property, which would follow with A's estate, but not on the property itself. That's one of the implications of a lien theory state, is that it will not sever the JTROS when one party takes a loan out on the property. So understand that Florida is a pure notice jurisdiction and a lien theory state. Mortgages are important to be able to talk about. A mortgage is a loan secured by property. A mortgage can be a purchase money mortgage, which means that the lender gave money and that money was used to purchase the property, and that PMM will have senior priority in the event of a foreclosure. A foreclosure is the forced sale of a property because the mortgagor has defaulted on payments. A mortgagor can take a mortgage subject to, or they can expressly assume a mortgage if they're taking on someone else's mortgage. Expressly assume means they're going to become primarily liable. Subject to means they're going to become secondarily liable. In the event of a novation, it would release the original party from liability. If there is a foreclosure sale, the proceeds will be used to pay off the senior mortgagee, and then the junior mortgagees will need to seek a deficiency judgment to collect from the mortgagor, and the senior mortgagee may need to do that as well if they're not paid off entirely. The equitable right of redemption is the mortgagor's right to buy back the property after a foreclosure has been initiated, but before the sale. And then the statutory right would be the right for the mortgagor to buy back the property, to redeem the property even after the sale. So mortgages, make sure you understand that it's a loan secured by property. In the event of non-payment, there can be a foreclosure sale, and the junior mortgagees will need to seek deficiency judgments to get paid if they are unpaid after the property has been sold. We talked about tenancies: joint tenancy with right of survivorship, tenancy in common, and tenancy by the entirety. We assume a tenancy in common, which means that if A and B are tenants in common and A were to die, A's heirs would take. A JTROS, a joint tenancy with the right of survivorship, is A and B are joint tenants, and if B were to die, then A would survive B. In order for there to be a joint tenancy with right of survivorship, there needs to be the four unities of time, title, interest, and possession. A tenancy by the entirety is a JTROS plus marriage, and Florida has eliminated the need for a straw man. A straw man at common law meant that in order to have that unity of time, if I owned a property, married Susie, I would need to convey it to the straw man. The straw man would convey it back to me and Susie so we could satisfy the element time, title, interest, and possession, and have a tenancy by the entirety. Florida's eliminated the need for that. Simply marriage plus JTROS will be a tenancy by the entirety in Florida. So Florida's a lien theory state, Florida's a pure notice jurisdiction, and there's different types of tenancies. So if you have a estate, you could have a life estate and there could be a remainder man. A life estate tenant has to pay the taxes and the living expenses and cannot commit waste. Waste can be actual affirmative waste. It could be permissive, where you just let the property go to waste, or it could be ameliorative, where you actually try to improve the property, but it's still against your rights as a life estate tenant, and you're not allowed to do that. And the grantor or the remainder man could potentially seek damages. The remainder man is the person who survives the life estate, and their duty is to pay the principal of the mortgage. So although we have a life estate tenant and a remainder man, we could very well have a tenant and a landlord in a leasehold, right? So landlord tenant duties, the landlord has the duty of habitability and quiet enjoyment. The tenant has the duty to pay rent and to not commit waste. They both may have duties of repairs depending on what needs to be repaired. The landlord duty of habitability and quiet enjoyment, those are interesting terms that'll come up in a minute, but just kind of hold on to them. Habitability means that the property is in good shape for living. There's no, leaking sewage or anything like that. And then quiet enjoyment means that no one's disturbing their ability to live in the home. The landlord's not just busting in, or the neighbor's not just busting in. We have this interesting mnemonic: your period will suffer, right? Tenancy for years, which is for a stated period of time. A periodic tenancy, which would be like month to month or year to year, it's kind of recurring. A tenancy at will, which means either the landlord or tenant could cancel at any time. And then a tenancy at sufferance, which is like a holdover tenant, where the tenant refuses to leave and the landlord, has remedies in that scenario. So when I said habitability and quiet enjoyment, they come up as landlord duties, but where else do they come up? Well, let's see quiet enjoyment. Quiet enjoyment is a warranty of a general warranty deed. There are three types of deeds: general warranty deeds, special warranty deeds, and quitclaim deeds. A general warranty deed has 6 covenants, 3 present and 3 future. The 3 present warranties are the warranties of seisin, the right against encumbrances, and the right to convey. The future warranties are quiet enjoyment, further assurances, and general warranties. So quiet enjoyment, it came up twice. It came up as a landlord duty, and it came up as a future warranty of a general warranty deed, right? But it means different things, because a general warranty deed is talking about the quiet enjoyment as a title, and then landlord tenants, quiet enjoyment of the use of the property. And then habitability, where could that come up? Well, in a land sale contract, you usually do not owe a duty of habitability unless it's a new construction home. Then the builder, or potentially even the first owner, may owe that duty of habitability. The builder definitely does. So that's where those duties could come up: duty of habitability, suitability, good workmanship. I've seen it referred to as all these different things. When we talk about a deed, remember, a deed is a position of ownership. It could also be a position of title. You have title by deed, but you could also have title by adverse possession. Let's say adverse possession is when someone gets title because they had open, continuous, exclusive, adverse, notorious, and hostile possession of the property for 7 years in Florida. There's color of title and without color of title. Color of title means you had a defective deed or some instrument that purported title. So if you have color of title, then you just had to have some encumbrance or improvement, some fence or improvement on the property. Without color of title means you didn't have a deed or anything purporting title, a defective deed or anything. And not only did you have to, improve or enclose a property, but you actually have had paid the taxes on the property to prevail in adverse possession claim without color of title. Remember, color of title means appearance of title. Adverse possession is very similar to prescriptive easement, so I might as well go over the easements. There's 6 different types of easements I could think of: express easement, implied easement, easement in gross, easement appurtenant, affirmative easement, negative easement, easement by prescription, and easement by necessity. Like I said, easement by prescription is similar to adverse possession, just without the element of exclusivity. Open, continuous, adverse, notorious, hostile for the statutory period of 20 years in Florida. That's a prescriptive easement. Easement by necessity means that the property is so hemmed in that it doesn't have access to a public road, and then therefore they would have that easement by necessity. Easement appurtenant is tied to the land, right? There's a dominant serving estate and it's going to run with the land. Easement in gross is personal in nature. It's like a utility company has the right to have a pole on your property or something. Express versus implied is pretty self-explanatory. And then the affirmative or negative easement. Affirmative easement is the right to cross or right of access, where negative easement is a restrictive easement, which are generally disallowed in Florida, except for riparian rights, water rights. But, you know, the Fontainebleau versus Eden Rock case is that landmark case that says you don't have the right to sunshine or a view or anything like that in Florida. So those are some considerations about easements and considerations about adverse possession. There's also covenant, real covenants, and equitable servitudes. They're promises tied to land. Like, I live in this townhouse in the Grove. We all have to paint our doors blue. That's an equitable servitude, because if I paint it red, they're going to require the injunctive remedy of me painting it back blue. If it was remedied by legal relief, by monetary relief, like if you park your car in this place for too long, you have to pay fines, that would be a covenant. They run with the land. If they touch and concern the land, there's notice, intent, and it generally should be in writing for there to be a covenant or equitable servitude and some sort of privity. But I won't jump down into that rabbit hole. So other issues that come up with real property, remember that contracts and real property are very similar. A real property contract will merge with the deed. And that concept of merger can come up twice too, because contracts merge with the deed, and also an owner who has a neighbor and they have an easement, and then the owner buys the neighbor's property, can merge the properties and terminate the easement. So merger can mean termination of an easement, or merger can mean the contract is going to merge with the deed. They like to test a lot in Florida this concept of concealment, misrepresentation, fraud, in the sense that, one party failed to disclose, right? Johnson v. Davis, another landmark Florida case, says that in the sale of residential real property, there's a duty to disclose latent defects that the owner knew about or should have known about. They do have a duty to disclose. So, think about that. Even if it's an as-is sale, it won't preclude them from liability if they fail to disclose, or they conceal, or they act fraudulently. And remember, land sale contracts need to be in writing to conform with the statute of frauds. Deeds need to be attested by 2 witnesses, accurately describe the land and identify the grantor and the grantee. These are some major considerations for real property. Also, like the homestead exemption can definitely be the basis of a real property essay. And other things that could come up for real property, a partition, a division of the property, if that's the proper remedy for joint tenants. A remainder man could not argue for petition. It wouldn't be proper for him to do that at that time. A tax deed is like, you apply for a tax credit, and if you pay the tax credit, you get a tax deed, which shows that you paid the taxes on the property. I mean, these are all considerations with real property. Maybe a takings issue, a constitutional issue. They need to provide full compensation for, a private taking. There's a regulatory taking, a possessory taking. A possessory taking means the government actually takes the land, where regulatory taking means some act or ordinance renders the property economically unviable or deprives them of their investment-backed expectations. Again, a lot of things that could be talked about on real property. I know I didn't get a chance to mention them all, but I think I probably got the juices flowing a little bit. Family law, I have a good mnemonic. JV Peast with a side of mustard. I don't know who fucking came up with this. I try not to curse tonight. Rats. Okay, whatever. Fuck it. If you watch this far, right? Fuck it. Okay, so the mnemonic that I have for Florida is JV Peast with a side of mustard, right? That shit made me curse. It's so weird. But J is for jurisdiction. So you got to consider, is there SMJ and PJ? The 6 month rule, whether the kid has lived there for 6 months, and whether there's continuous jurisdiction where the final settlement was ordered, exclusive continuing jurisdiction, things like that, and subject matter jurisdiction and venue, right? The proper location. So first have that jurisdictional discussion, and then the P stands for parenting plan, equitable distribution, alimony, child support, everything else, esquire fees, divorce, dissolution, and then the M is for modification, right? These are some points you could think about. So the parenting plan that's really going to describe, how we're going to divide the time, whether it's going to be sole or split or shared or whatever it may be. I mean, sole is very rare because you do have a constitutional right in Florida to the upbringing of your child. The grandparents could even have a right to be involved in certain circumstances. So even adoptive parents have rights, right? Like an adopted parent it's treated like a biological parent, right? And then the parenting plan will really regulate how the parenting is going to be handled. And remember, the key phrase to use is the best interest of the child. Talk about all these different factors like the education, who's better at this, who has more time, the kid's preference, all these things, but the best interest of the child will always be prevailing. The E stands for equitable distribution. So in Florida, we're going to separate marital and non-marital property. The separate, and then the marital property will be split equitably, right? Which is usually evenly, but there could be reasons for doing it equitably. So let's say there's a pension plan. For the time they were married, they were a marital. It was marital property, so that part that goes towards the pension maybe would go to the particular spouse, right? So, the E is for equitable distribution. I mean, again, that's probably for an alimony, but sorry, equitable distribution is going to be how properties split, like the homes, the cars, things like that. It'll be split equitably considering marital property. Remember the homestead exemption, it could be a consideration in property and wills in con law about how the homeowner and the spouse and the minor children have rights in the homestead property. And then A is for alimony. That's what I was talking about more about the pension and, different types of alimony. There's no longer permanent alimony in Florida unless you're grandfathered in. There's durational alimony, which can last for a pretty long duration. There's temporary alimony, pendente light alimony, which is like during the trial. There's bridge the gap alimony, kind of like to bridge the gap. There's rehabilitational alimony, which is like to get someone back on their feet. So a lot of different types of alimony. Remember, no more permanent alimony in Florida. So I think I said temporary, pendente light, bridge the gap, durational, and no longer permanent. There might even be another type of alimony I can't remember, but a lot of different types of alimony that we can consider and we can argue for. And then the PEAC is for child support. Child support cannot be waived in a prenuptial agreement, whereas alimony can. And again, best interest of the child and things of that nature are going to determine child support. I think E was for like esquire fees, like they can be stipulated that the other side pays for attorney's fees in a particular contract dispute. Florida is a no-fault divorce state. So for divorce and dissolution, they'll allow divorce if the marriage is irretrievably broken or either party has been adjudicated mentally incompetent for 3 years or more. They could order you to go to additional counseling before allowing it to be irretrievably broken, but I think that's pretty rare. The difference between a divorce and an annulment is like the marriage never happened, where a divorce is a true proper divorce. And then the modifications will be allowable if there's a petition to the court and it's if there's a significant change in circumstances. It used to have to be unanticipated, but they've abridged that, and now it just has to be a substantial change in circumstance. So, the family law essay, I think, writes itself. Just kind of remember times when people went through divorces and how it may have gone. Florida has the statutory guidelines, and it's difficult to deviate over 5% from the statutory guidelines. You have to show cause, right? And then we have ethics. Ethics is great. You can talk about where the rules of ethics derive from. And I have this great little paragraph that I'll show y'all that's in my book about, the Supreme Court and the oath and the creed and different documents where the rules will derive from. And I think that's a great way to start any ethics discussion. And again, I'll read that to y'all from the book before we end. And then, different types of ethical rules that could be implicated would be like the duty of candor, the duty of decorum, and the duty of competency. So pretty much to just act properly and to, take on representation that you are knowledgeable of and can handle the representation, and not to lie, not to submit frivolous claims, to be respectful, all of these different concepts. There's definitely going to be a concept of legal fees, right? There's referral fees and there's contingency fees. Referral fees are not allowed in Florida unless they're agreed in writing by the client and the person's actually going to participate in the litigation. And then contingency fees, also, they need the client's consent and written agreement, and it needs to be calculated both before to the client, how it's going to be calculated, and then after when the calculation is done. And again, contingency fees need to be reasonable for the client. So referral fees, contingency fees. Another big concept would be conflict of interest. And it pretty much, it jumps off the page to you that the attorney may have a conflict of interest and he can't take on that representation unless he can reasonably represent the client without sacrificing their legal and professional judgment. There could be the concept of screening out an attorney, because otherwise the conflict could be imputed to the rest of the firm. In general, when it comes to these ethical issues, you really just got to take the stance that what the attorney's doing maybe have an air of impropriety, and it should be recommended that they don't particularly act that way. They get the client's consent and they act in good faith, and they don't breach any duties they have, including a conflict of interest duty. So I really think that was a pretty good summary of some of the key points that you may see when it comes to contracts, torts, con law through the three lenses, which is federal, Florida, and concrim, real property, family law, and ethics. Of course, I didn't cover everything, but I tried to cover the most important basics. And just, quickly, as I promised the class, I wanted to show y'all my guidebook that I think is really instructive, and hopefully I didn't miss too much of anything, but you could see that the things I missed can likely be revisited in my essay guidebook. So it's usually under the reading of the week. The Legend of Stick Boy, so rest in peace to my grandfather. That's Big Dog himself right there. Probably the best attorney to ever live. Him and my other grandfather, in my opinion, whatever. So these are the contract points, like body of law. I talked about different types of contracts. I didn't miss a beat. Formation, we talked about all these points. The mailbox rule we didn't mention, but offers are effective upon receipt, where acceptances are effective upon dispatch. Advertisements not really going to constitute an offer unless it's very specific. and it could be, accepted. Talked about all these different defenses. I don't think I really missed any. Yeah, it was pretty nice. Breaches, material breach, perfect tender rule, modifications, equitable, legal relief, consequential, incidental, all the different types of damages, parole evidence, non-compete, liquidate damages, according to satisfaction, TPBs. I think I pretty much crushed it. Contracts, I kind of did the most thoroughly, I would say. And then torts, modified comparative fault, abolished joint several liability, 3 times compensatory, $500,000, all good stuff. Good Samaritan rule and the firefighter rule, right? So like, a cop can't sue someone who's, if a cop gets injured trying to, come to the scene. That's like the cop's job, right? And then the Good Samaritan rule, professionals try to help someone, they're going to be protected from liability. We talked about negligence per se, vicarious liability, res ipsa, strict liability, breach, causation. This is important. Superseding and intervening. Try to use those buzzwords, right? Superseding should cut off liability, whereas intervening would lead to contribution, but not true indemnity. And then, top types of damages. You want to talk about this, like compensatory damages include pain and suffering, emotional distress and mental anguish, medical expenses, loss of wages, diminished earning capacity, loss of consortium, the ability to share one's company, and out-of-pocket expenses. It's important to note that for proxy liability cases, Florida follows the economic loss doctrine, which states that a plaintiff cannot recover for purely economic losses, since that would more properly constitute a breach of contract claim, right? Eggshell plaintiff rule, you take the plaintiff as you find them. NIED, bystander cases. Florida dram shop laws, a person who sells or furnishes alcoholic beverages to a person of lawful drinking age shall not thereby become liable for injury or damage caused by or resulting from the intoxication of such person. They mentioned that. Talk about the intentional torts. I think I hit them all. Defamation, definitely some pieces. Invasion of privacy, premise liability, proxy liability. Wrongful life is not recognized in Florida. Wrongful birth would be brought by the parents, very difficult to recover. Wrongful death, different from survivorship claim, because wrongful death is like malpractice, how they died, where survivorship claim is like claims that were lingering that the estate can bring on the decedent's behalf. Medical malpractice, right? They have to provide notice and give them the opportunity for arbitration or mediation, and damages are limited. And then nuisance, right? Speaking of nuisance, Rosie or Biscuit started barking. I wrote this a couple years ago. I'm writing an MBE book right now, but my students gave me too much headaches for me to finish. All right, so yeah, con law, state action, standing, justiciability, Fifth Amendment, equal protection, First Amendment, different forums, freedom of religion, fundamental rights, access to court, scrutiny levels, vagueness, overbreadth. Ooh, separation of powers is a tough one. Hard to see, but remember there's legislative, executive, and judicial powers and duties, and it's not going to be okay if there's encroachment, entanglement, entwinement, usurpation, or any type of commingling between the branches. Takings, eminent domain, 10th Amendment, state sovereignty, 11th Amendment, sovereign immunity, Commerce Clause, Dormant Commerce Clause, privilege immunities, anti-commandeering, ex post facto law, can't punish retroactively. Contracts clause, bill of attainder, double jeopardy. I mean, these things aren't tested heavily, but you should know them definitely for the MBE, right? And then Florida Sunshine Law, homestead exemption, enacting a law, types of laws, home rule power, chartered counties versus unchartered counties. Chartered counties have home rule power and can, enact laws, special legislative sessions. Again, separation of powers. This one came from my year, February 2017. I think I had the hardest essays ever tested, right? Turned me into a monster, right? So constitutional officers in Florida include the governor, the lieutenant governor, the CFO, the Commission of Agriculture, state attorneys, public defenders, sheriffs, tax collectors, property appraisers, supervisors of elections, clerks of the circuit court, county commissioners, district school board members, and superintendents of schools. These elected officers have vested duties and must complete relevant ethics courses. Talk about the Kluger Doctrine, the 60% for the amendments. Defamation can come up in con law a little bit because of the non-protected speech, right? Obscenity, the hate speech, words likely to incite imminent loss activity, defamation, false or misleading commercial speech. These are all not protected. Florida has this express right to privacy, a right to work. Talked about municipal bonds. cannot set excessive bail, right? Taxation consideration, it's the municipality and counties that levy them, not the state. Convicted felons, they can't vote or run for office unless they've had their voting rights restored, right? Clemency. Pocket vetoes, not in Florida. Florida can do advisory opinions. Judicial procedure, right? The legislator passes a bill by majority of each house and then presents it, but they may reject such rules created by the Florida Supreme Court by a 2/3 vote, but they may not amend or modify such rules. Again, prohibited subject matters. So I've seen this tested before. Special laws as well as general laws of local application cannot cover certain subject matter that the Florida Constitution expressly prohibits. Such prohibited subject matter includes taxation, elections, petite juries, conditions precedent to bring civil or criminal claims, venue rules, and rules of evidence. These subject matters are preempted by Florida state law. The Florida Supreme Court has original jurisdiction over certain matters, right? Two DCA opinions, mandatory discretion for bond validation proceedings, imposition of the death penalty, and the invalidation of a state statute or constitutional provision. And then the con-crim ones, we talked about this: Fourth, Fifth Amendment, Miranda rights, custody, Sixth Amendment right to counsel, exclusionary rule for the poisonous tree doctrine, warrant requirements, the specious mnemonic as the exception to the warrant, reasonable expectation of privacy, stand your ground laws. In Florida, a person is justified in using or threatening to use force except deadly force unless it's reasonably necessary against another when and to the extent that the person reasonably believes that such conduct is necessary to defend themselves, right? Impermissibly suggestive lineups, if they were looking for Kevin Hart and they show us a bunch of Shaquille O'Neals, right? And then they could even talk about robbery. And I love this dude's website right here, Hornsby. This is my guy. Him and IBIS Prep have been voted best of business. We've won this 3 years in a row right now, going for 4. But anywho, if you go for Florida crimes, we tutor for a lot of subjects, right? For kids and all that. Y'all just see the bar prep aspect. But anywho, this is a crimes for Florida. There's a lot of good ones. I really like how he does homicide, the different degrees of murder and such. I mean, he crushes it. I really like this dude Hornsby. So I'll pass the mic to him if you want to look for the robbery, murder, and manslaughter and these things. It's not heavily tested on Florida essays, but conceivably it could. So you want to be ready for it. And then property, right? I gave you this great vocabulary list that my classmate in MBE class that we've doctored up. I think it's pretty nice. A lot of vocabulary words because I think real property is truly a vocabulary test. And if you know these vocab words, you can't struggle. Peace be the journey. That's what my friend who signed everyone's yearbook in the 8th grade. I stole that from him. Okay, so right, Florida's a lien theory state, pure no jurisdiction, BFP, different types of notices, different types of tenancies, mortgages we talked about, rights of redemption, different types of easements, covenants, servitudes, adverse possession, homestead property, habitability and quiet enjoyment, constructive evictions, right? When it's so bad that the landlord has 15 days to give back a security deposit, unless they're making a claim in which they have 30 days. Constructive eviction was a landlord actions cause the injury. The resulting conditions must be so bad that render the place inhabitable and the tenant must actually vacate the property. So to claim a construction eviction, you have to actually vacate the property. Right, we did your period will suffer, tenancy for years, periodic tenancy, tenancy at will, and the holdover tenant situation. So a year-to-year lease requires 60 days notice for residential periodic tenancies and 90 days notice for commercial leases. Quarter to quarter is 30 days for residential and 45 for commercial. And then month to month is 15 for residential and commercial, and week to week is 7 days required notice for residential and commercial leases, right? So land sale contracts, statute of frauds, due to disclose. As is a general disclaimer. And again, Florida's the Johnson v. Davis, so it might be effective for a specific disclaimer, like the condition of the roof, but not for the entire property in a residential land sale because of Johnson v. Davis. So look for concealment, misrepresentation, Puffy. We're not really down with Puff Daddy these days. All conveyances have a marketable title implied warranty, which means there's no encumbrances, mortgages, liens, threats of litigation, weird zoning ordinances. It wasn't acquired by adverse possession. It doesn't have any terminal fee conditions on it or the feasible fee conditions. Like anything that would make it strange would be violation of the implied warranty of marketable title. Equitable conversion means the risk of loss will pass to the buyer after the contract is agreed upon, but before the closing during that period of escrow, right? And it also means that both parties after the land sale contract is agreed upon, but before the closing, if either party dies, their heirs will have to follow through with the closing because the property is already converted in equitable terms. So deed, we talked about deed formalities, signed, written, attested by 2 witnesses. Special warranty deeds is only for the time they had ownership, whereas general warranty deed has the 6 covenants. And then a quitclaim deed, isn't really giving any promises about title at all. And then family law, MJ pieced with the side of mustard, right? Jurisdiction, the UCCJEA, Uniform Child Custody Jurisdiction Enforcement Act, right, where they live for at least 6 months. Venue, where at least one of the spouses resides, where the marriage last existed, or where the breach that occurred. Parenting plan, best interest of the child. Split, ultimate, sole parenting, but sole parenting only when they're a danger to the child. There is a constitutional right to be involved in the upbringing of your child, so that would be a really serious measure. Equitable distribution, talking about marital and non-marital property and splitting it. You can waive alimony, equitable distribution, and all that. You can't waive child support. So alimony, temporary, pendente light, rehabilitated, bridge the gap, durational, and then no longer awards permanent, but they can be grandfathered in. And yeah, they've changed the terms. It used to be 717 and stuff, but now it's 1020 for short, long term, easier to memorize. Child support in Florida, child support is determined based on state guidelines. Any deviation from the guidelines by more than 5% will require the judge to show findings to support the deviation. The amount is then allocated between the parents according to their respective need and ability to pay. If a child is spending 20% of nights with the person paying child support, there must be an adjustment. Child support will be determined by the best interest of the child, right? Dissolution, irretrievably broken, no fault divorce, or mentally incompetent for 3 years. Modification, material change in circumstance, right? No longer requires it to be unanticipated. And then prenups, right? They have to be in writing, obviously. Postnups, they should be in writing, right? And then adoptions. In Florida, the effective adoption is that the child has the same legal rights as a biological child. In Florida, single adults or married couples may jointly adopt. All adoptive parents must be approved through an adoption home study, as well as meet any additional requirements from their private agency. Grandparents, aunts, uncles, and siblings can adopt through kinship adoption, which is a quicker and less expensive process compared to regular adoptions. All right, and then finally, ethics. This is the one that I'm going to leave you all with tonight because, in my opinion, when you're sitting for the bar exam and it's Florida essays, it's the first thing you got to knock it out of the park. Well, they're going to test ethics. And when they test ethics, you're guaranteed you can write this statement. And if you can write this statement, well, you might even be able to copy and paste it and write it 2, if not 3 times. So if it were me and I'm sitting there and people are looking nervous Nancy's all over and around, I would be just reciting this statement over and over. And then once the test starts, I would just spit it out, get it on my paper, and then copy and paste it for any place where it asked me to write about ethics. So the ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for non-compliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. That's a bulletproof way to start the ethics discussion. Duty of confidentiality, I didn't mention, but it's broader than the attorney-client privilege, right? So, the duty of confidentiality means that everything that is said in confidence between an attorney and client is supposed to be very sacred and protected. Competence, candor, and decorum, conflict of interest, imputation, and screening. Attorney's fees, right, have to be reasonable and are considered clearly excessive when they're overreaching or unconscionable. Duty not to commingle funds. Contingency fees, right, they're not allowable in domestic or criminal cases. Otherwise, they must be in writing and have the calculations. Referral fees are not ethical unless divided proportionally to the work performed, right? And then interest in client property.
In order for an attorney to receive an interest in client property, the lawyer must get the client's informed consent, and the agreement must be fair and reasonable and disclosed in writing. The client must be advised of the opportunity to seek outside counsel. Advertisements, right? You have to have their name and field, the name and field that you practice in, and the your number, your bar number, and things like that. It can't be false or misleading, like claiming 100% success rate after winning a single case. Solicitation, remember the accident victim, you have to wait 30 days to chase that ambulance. The rules of private practice. So, if you're barred in Florida, you can't practice unless you're associated with an active local lawyer, you're granted pro hac visa admission, or the litigation arises out of the home state practice. Mediation, arbitration. Mediation is when the decision is non-binding, whereas arbitration is when the decision is actually binding on both parties. And then one more time for good measure, the ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. I'm very confident in each and every one of you. And as my grandma always used to say, please be a good person. I'm going to stop this recording.